everyone, my name is Rebecca and I'm an associate attorney here at Richards & Jarusic, and today we're going to be talking about whether it's possible for you to apply for a visitor visa while you have a pending I-130 petition for an alien relative. So starting with that I-130, what that application is meant to do is simply establish the relationship between yourself and the qualifying U.S. citizen or lawful permanent resident relative. So spouse, parent, child. That's it. That application is just meant to establish that relationship to the government. That in itself does not declare your immigrant intent to move to the U.S. permanently. That intent is not declared until you are either filing an adjustment of status application from inside the U.S. or filing a consular processing application with a U.S. consulate abroad. Now, the B-2 visa is, of course, a non-immigrant temporary status that you are seeking. So officers are looking to see that you are coming to visit for a limited period of time and you have the intent to return home at the end of that visit. The key issue here, what it comes down to, is that intent problem. So how are they going to issue a B-2 visa if they see that you have this pending I-130? So because the pending I-130 does not declare your immigrant intent, that's what allows you to apply for the visitor visa. It doesn't guarantee approval, but it allows you to apply. Where things get tricky is the adjudication of the visitor visa, because officers can see that you have that pending I-130, which in a sense shows that you have future intent to come to the US, and they need to be able to decipher that future intent from your present intent to just temporarily visit. So you need to satisfy those officers that you have solid plans to return, meaning you have a return ticket, you have proof of your ties to your home country. That looks like bank statements, mortgage statements, lease agreement, anything tying you to an address in your home country. That's essentially what they're looking for. A lot of times when they see you have a US citizen spouse and you're coming to visit the US, they have questions because they're automatically programmed to think that you have that permanent intent. So you need to be able to satisfy the officers that that's not the case. Now, other things that officers take into consideration is your previous travel history to the US. Say you've previously had a visitor visa or some other status and you spend a lot of time in the US or you make frequent trips back and forth. That is another reason for them to question what your true intent is. So it's important to take all of these factors into consideration and just know that it's not impossible for you to apply and obtain a visitor visa, but it's going to be tricky and denials are common and likely to happen in certain situations. So that's just important to keep in mind before pursuing any sort of non-immigrant status while you have a pending I-130. And of course, if you have any questions at all about this process or how to do so in an effective way, we are always available to discuss. So if you have any questions about getting a visitor visa at all, feel free to reach out to our firm and we're happy to assist you and guide you through that process. Thank you for watching.